Both parties have the ability to appeal that. Why are we here today doing the opposite? Because they want to enforce a two-party system, divide Iowans, and limit their choices. Questions?
I understand you stressed down there your opinion that this panel didn't have standing to do this, that the objections as written code centered around the nomination petition to the certificate of nomination. The code does read or to the eligibility of cover the objections that were raised here.
No, the eligibility of the candidate has to do with part of the information that has to be provided regarding the eligibility of the candidate. For example, their address, where they live, whether or not they've ever been convicted of a felony.
Why does it not matter when they ask about affidavits?
I'm not convinced that that doesn't matter. We just have two names from two people who if they haven't provided an affidavit, that they live in the state of Iowa and they haven't provided their address, I don't know if they've met their burden. But obviously the other two folks on the panel weren't concerned about that. They are happy to push these people off of the ballot and force them to have a race against time to see if they can have their case heard before ballots are printed.
Why did your colleagues on the panel didn't discuss the issue you raised in terms of standing of Republican voters don't have standing to challenge Libertarian Party internal convention?
Right.
I guess there was a brief recess. I mean,
I'm answering this question. I don't think it's something that you guys want to include. It had to do with Mr. Brubaker's presence and approach moved towards the panel. Most of you probably know him. If you don't, everyone else can tell you stories. But no, they weren't interested in the point about standing, were they? They didn't really seem to be interested in much. Waving around a code book to make it look like you're following Iowa law while ignoring the words that were in it. You know, counsel for the objectors, when we had this panel in 2022, you may recall, asked me to recuse myself because he had pending litigation with our office. That litigation is still pending. Why do you suppose he didn't ask me to recuse myself this time? Fix was in. He knew he didn't have to. He knew he already had the 2 votes he wanted. Why didn't he respond to any of my objections? Why didn't he tell me why I was wrong? He already had the 2 votes he needed, and he knew it.
What would it take for anything, all of the objections, all the concerns about this, be a little ignorant in this question, but code have to change? There seem to be some gray areas that have been left panel today to interpret how they proceed. Where are all of these things? Or should they be spelled out?
Well, I assume that it'll go to Iowa's courts. I don't think that there's much gray. I really don't. The statute lays out what you can object for. It doesn't say you can poke around in a minority party's business and try to find something where they screwed up to make an objection to, right? That's the party's business. Why am I the only one that cares about the Constitution, right? The only thing I didn't have today that I wish I had had, and I meant to ask for it and then I forgot to, I bet somebody in that room had a pocket copy of the Constitution. And we could have just laid that pocket copy of the Constitution down on top of the Code of Iowa, because the Code of Iowa submits to the Constitution of the United States. And the United States Supreme Court has repeatedly stated that you cannot, as a state, create laws that nitpick and tell political parties what to do because of the First Amendment of the United States Constitution and the Bill of Rights. You can't do that. What are we doing here today? We're just ignoring it. Nobody wanted to tell me why I was wrong. Nobody argued against the fact that those 3 or 4 US Supreme Court decisions were on point because they didn't have to. They were just relying on their ability to exert power, knowing that they had 2 of the votes on a 3-person panel. They didn't want to tell anybody why I was wrong. They didn't want to say, no, actually, those cases mean something else, because they weren't worried about it. They weren't worried about right or wrong, to be clear.
We're not as concerned about the fact that the party didn't follow.
Same reasons I had for my vote to deny the objection. They raised objections that are unconstitutional objections, right? The United States Supreme Court has said it 3 or 4 times, right? They raised objections that aren't in Iowa law. The statute says sufficiency of the certificate. The statute says sufficiency of the nomination panel. It also does say qualifications, right? It does not say and party procedure regarding the nomination. So you could have had an objection for saying, I don't like Marco Battaglia because he looked at me funny. And I would have been equally unconcerned with that objection.
I believe assuming they do and they that's challenge this panel's ruling in the court that they have a legal argument.
Absolutely. We did this in 2022. And I defended Iowa's courts when a fellow member of my party attacked them at the district court level for booting her from the ballot at the district court level. I pointed out that that judge worked very hard all weekend long, not only to consider the issues, but to write an opinion and do it in time to get an opinion issued. And I stated that even though that judge in that opinion stated the opinion that was the opposite of my own. I'm hopeful that in this case, Iowa's judicial system is going to give the same time and attention as they did to that case in 2022. And I think they did a fine job of doing it then. That decision at the district court level was reversed by the Iowa Supreme Court, which did reach the same decision that I had reached on that panel. Anybody got anything else?